Good morning and welcome to AM News Network Presents the Morning Report with Rachel Baird and Ed Peruta. I'm Rachel Baird. This is Ed Peruta. We're here every Monday through Thursday from 7 to 7:30 a.m. Also join us on Saturday for our show Summary Judgment, where we're joined by Matt Tyszkka. I'm not sure Matt's going to be here this week, but not next week. And we're going to have as a guest this week Brooke Cheney. She's going to come talk about her trip to Washington, D.C. So good morning, Ed.
Good morning. Today is June 14th, 2017. It is Flag Day.
And we're not quite sure what the meaning of that is. Maybe somebody will call in and help us along with that. We wouldn't mind.
It's like Kwanzaa.
No, I don't think it is. So what do you have on your mind? Get started. I have something I want to talk about. In Massachusetts, let's talk about permitting issues for a little while. In Massachusetts, to obtain a non-resident license to carry, you submit an application.
Right.
To the Firearms Bureau up there, okay?
Right.
Now, the statute pertaining to non-resident licenses to carry, they call it an LTC, is kind of like our eligibility certificate down here in Connecticut. It just lists things that disqualify you from getting it. It doesn't have any specific reference to suitability or just cause or anything like that. And this was brought up in a 2013 Supreme Court case in Massachusetts where the petitioner who had been denied a license to carry said there's no suitability requirement in the application for non-resident permits because it's not specified in the statute. And the Massachusetts Supreme Court said, well, residents are subject to a suitability requirement, and it would make absolutely no sense to have residents subject to a suitability requirement and not to have non-residents not subject to a suitability requirement. So we're going to incorporate the suitability requirement for residents into the non-resident statute because you have to consider the chapter as a whole.
But let me ask you a question.
Yeah.
In order to get a non-resident permit in Connecticut, you must possess a permit in another state.
Same in Massachusetts.
So the reason the legislature didn't put suitability into non-resident is you've met a suitability requirement in another state.
Well, this incorporates the whole reciprocity bill that's pending before Congress and how important it is because what if the permits that you already have when you're applying for your non-resident permit are shall issue states? So maybe there was no suitability evaluation done on you in the other states. What do you have to say to that? That's a possibility.
You are carrying on a permit from another state in multiple states under the reciprocity between states. Mm-hmm. You could be 30, 40 states right. Permitting you to carry.
No doubt.
And then they want to put a condition of suitability. Well, if you've had your permit for a period of time and you've had no incidents with the permit, then I believe you're a suitable person.
Well, but isn't that the whole reason why we're pushing for reciprocity, law? Because that's not the way it works right now. Massachusetts can make its own rules now, and even though you can carry in 40 other states, all of a sudden
under national reciprocity, how are they going to deal with constitutional carry states like Vermont, where you don't need a permit?
What do you mean, how are you going to deal with it?
Well, reciprocal agreement. You can carry in Vermont, you can carry here. But Vermont never issued me a piece of paper saying I carry this in my wallet, here's my permission.
Well, that's a good thought. We should look at the text of the proposed reciprocity bill and see if the people who are writing it actually know what's going on, because we've talked about that a lot in Connecticut.
I'm more concerned with the fact that these pistol permit applications say, have you ever been arrested? And you may have been arrested, and the charges may have been dropped on your first appearance when the prosecutor sees how ridiculous the charges are. But you have to tell them, I got arrested for this, but I was never convicted of that.
Well, the question in Massachusetts on the non-resident permit application, have you ever been arrested or appeared in court as a defendant for any criminal offense? And the issue yesterday in Massachusetts was, can you be arrested for something that is defined as other than a criminal offense? And the judge seemed to think no, and I was arguing you could. And I said, the question says, have you ever been arrested or appeared in court as a defendant for any criminal offense? If the only way you can be arrested is if it's for a criminal offense, then why does it go on to say for any criminal offense? It would make it superfluous. Why doesn't it just say, have you ever been arrested or appeared in court as a defendant? Or have you ever been arrested? It doesn't need to say for any criminal offense.
This is the same state that had a major scandal in their forensic crime lab where people may have been arrested that should never have been arrested.
You could picture it where this question, have you ever been arrested, could lead to abuse, where police officers don't need a warrant to arrest people. They can arrest you for anything at any time. And it could be dismissed, you could be pardoned, you could go before a jury, not guilty. And in Massachusetts, they still want you to have to say, you've been arrested. And
What if the
I actually said yesterday, what if you've been pardoned? Do you still, under this application, you have to still say you've been arrested? How can that be? That needs to change, because that's not right.
Why? Here's what they're looking for. Have you ever been confronted by law enforcement as the suspect in a criminal offense? That's really what they're looking for. Now, does the legislature in Massachusetts say everybody is a criminal, not everybody gets convicted?
And the question goes on to say, do not include non-criminal information such as speeding.
Right.
So it clearly says, if it's an infraction, you do not need to include it. Now, there is a Supreme Court case where a woman was arrested for not wearing her seatbelt, and the case is called Atwater, Atwater versus City of Lago Vista, and she was arrested for not having her seatbelt on, and they took it up to the Supreme Court saying, how can you put somebody in custody for a minor offense like this? And the Supreme Court went, in that state, I guess not wearing a seatbelt is considered a misdemeanor criminal offense. But then at the end of the case, and this is a 2001 case, at the end of the case, in the appendix, thank you very much, Supreme Court, it listed every state and the law which applies in that state to what defines a criminal offense, what defines an infraction or whatever. And so if you look at the appendix to that case, under New York law, arrest without a warrant, subject to the provisions of subdivision 2, a police officer may arrest a person. So a police officer can arrest a person for any offense when he or she has reasonable cause to believe that such person has committed such offense in his or her presence. B, a crime when he or she has reasonable cause to believe that such person has committed such crime, whether in his presence or otherwise. So why do we have these two sections? The one section, if you do something, an offense, and the police officer sees it, he can arrest you for it. The other, if it's a crime, and the police officer has reasonable cause to believe that you committed it, whether in his presence or not, he can arrest you. Well, we all know about the second one. You know, probable cause, he can arrest you, that crime, whether he was there or not. But what are they talking about under A? where the police officer can arrest you for any offense what's any offense? There must be a difference between A and B is talking about a crime, and A is talking about offense. So New York clearly contemplates that you can be arrested for something other than a crime.
Well, let's get to the heart of this in my mind. The Supreme Court in McDonald applied Heller to all the states. Heller was D.C., McDonald said 14th Amendment, it's good in every federal jurisdiction. Out in the islands of the Pacific, the territories, it's the law of the land. How can you have a constitutional right which is infringed like patchwork quilting across the country? In other words, even in the state of Connecticut, one chief issuing authority may find you unsuitable, but the chief in the next town, given the same facts and circumstances, can find you suitable. One state can say, when your charges are dismissed, and I quote Richard Tulisano, this is where I learned the word, ab initio. When your case is dismissed, it is dismissed ab initio. It never occurred. Now, I carry that language of the state of Connecticut to the state of California. And I go, I was never arrested on the day that I was arrested. It was ab initio, wiped clean, gone, forget it, don't list it anywhere because it never happened. But then the next state says, no, we don't agree with that. If you got arrested and you went to court and you got the charge dismissed on the first day, you were still arrested. In other words, you had a negative encounter with law enforcement. You were the suspect in something. You were confronted by law enforcement. And I remember Chief Philip Schnabel of the Rocky Hill Police Department, who was terminated and rode out of town on a rail. When a person is charged and they went to court in New Britain, the court dismissed the charges. The court tells the central records for judicial the case was dismissed, and judicial sends the paperwork to the police department, and the police department is required by law to go into their booking book and erase and remove all references to the arrest. When it was found that there were in excess of 10,000 records of dismissals in the Rocky Hill Police Department that had not been removed from the booking book, Chief Schnabel's comment was this: if they got arrested, they were guilty.
Right, and that is the danger in when people are exonerated, not guilty, when it's dismissed. You could, under the scenario in Massachusetts, you could get arrested, be found not guilty by a jury, sue the police department, get millions of dollars for false arrest, and go apply for a permit and still have to put down that you were arrested.
Right.
There's something really wrong with that.
The way that the Rocky Hill incident became public, there was a detective in the state's attorney's office by the name of D. Cicenti. D. Cicenti grew up in Wethersfield. I knew him before he was a policeman. He had a son. The son got arrested. The son went to court. The son got the charges dismissed. And the son joined the U.S. Army. And on the application said, have you ever been arrested? He said, no. He was on the plane at Bradley Field, ready to fly to Fort Leonard Wood, Missouri for training. And the recruiters came up onto the plane and took him off and said, you lied to us. You told us you were never arrested. your name's in the book, in the booking log of the Rocky Hill Police Department. That is what started the whole thing with looking into how did this record exist when the court said to erase it and eradicate it from the record. That's when 10,000 were found. Schnabel made the statement. They had to hire like 10 part-time people to come in and work the records to clean it up.
Hey Ed, if you marry somebody and they're already married, that's polygamy for them, right?
Right.
So, is your marriage valid, or is it just ab initio, like not valid? Do you know?
I don't know.
Let's assume it's not. Well, let's assume if you marry somebody and they're already married, that you weren't really married.
Right.
Okay. So then if you're filling out an application that says, were you ever married? Well, it's in the newspaper, the wedding announcement, the pictures, the dress, everything
There's
else.
a marriage license on
There's
file.
a marriage license. So but you would answer no, because it turned out not to be valid.
It was invalid. And if somebody doesn't erase the record, someone would just simply read
she was
well,
married.
Now let me explain. When you go to government meetings, I used to sit at home and watch a town council meeting on television. And I would hear either a member of the public go to the podium or a member of the council speaking to an issue that I was involved in. And let's say they said, Ed Peruta was in his car yesterday and struck a pedestrian on the Silestein Highway. Now I'm sitting at home and I know that that's not true. I would get in my car and drive down to town hall and insist to go to the podium and say, I'm here to correct the record. This is why. I said, 100 years from now, someone will be doing research on Ed Peruta. They will look at the town record.
No
They
doubt.
will look at the minutes of the town council, and they will see a reference to my striking somebody with a vehicle on the Silestein Highway in Rocky Hill. And because I'm not alive and there's nobody alive, they take that as gospel because it's in the public record. You have to get it out of the public record.
I was watching a documentary last night about Leon Trotsky,
Yeah.
and that's exactly what Stalin did to him. I mean, he changed the whole history of the communist uprising, the revolution, and it literally erased him from the books about his participation in it. And when people look back on it, that's what they saw. Well, it's been obviously revised since then. Who the hell knows what's the truth now? I mean, that often happens. But yeah, you have to make
The
you have to
revisionists
set the record straight.
The revisionists tend to eradicate. Well, in Egypt, they used to chip off the cartouche of the pharaoh if they didn't like him. They eliminated every image of him to get rid of him.
Well, and come to think of it, you know that I have certain eccentricities sometimes, and I guess it runs in my family because I used to do this. I don't do it as much anymore, but I'm told that some of my ancestors did it as well, going back a generation or two or three. When I'm mad at somebody, I will turn their picture over. Like if I have a picture of them, and that's sort of erasing them for that time period. And then when you're over it, you put the picture back up, But yeah, that's sort of a personal way of revising history for the moment when you're mad at somebody. Let's talk about...
That is funny.
Let's talk about Neil Gorsuch. He wrote his first opinion yesterday for the Supreme Court. I have not read it, but I want to. I want to read his first opinion. It's about the Fair Debt Collection Practices Act. You're going to love his opinion. I love his opinion. It was unanimous. Everybody joined in. But my understanding from my brief review of the opinion is that under the Fair Debt Collection Practices Act, if you're a debt collector, and that includes attorneys, you have to put a big notice in bold. This is from a debt collector, whatever. There's some notice there. I don't do it. Anything you send out, you have to put that notice on it. And there's other things you have to do too. If people tell you not to call them, you can't call them, certain hours, all these other things. And if a debt collector violates that, then you can sue them and get attorney's fees and damages.
Quite
and
a
all
bit of
that.
money.
Yeah, and a lot of money's made through class actions on these. Well, I guess the issue was it included Santander Bank, Santander. I think it's from South America or something. I'm not sure. Well, they got certain loans. They bought them.
They bought loans from other lenders.
Right, and so they were attempting to collect the debts on these loans, and they didn't follow the provisions of the Fair Debt Collection Practices Act. They didn't put notices up or anything like that. So the question was, did they violate the Fair Debt Collection Practices Act? Because who is a debt collector? Well, Supreme Court Justice Neil Gorsuch wrote an opinion saying, you know what? If you look at the way this law is written, the way Congress wrote it, it says if you're trying to collect a debt on behalf of somebody else, you're a debt collector. Santander Bank was trying to collect the debt on behalf of themselves, so they are not a debt collector. And so they are not subject to the Fair Debt Collection Practices Act. Santander Bank wins. And you know what? If Congress, you meant it to be different and you don't like this result, then you go back to the books and you change it. Thank you very much.
That has been the battle cry of this law firm for at least 9.5 years. Mm-hmm. Is if you don't put the extra $50 fee into the statute, you're not entitled to collect it. If you don't clearly exempt the applicants for pistol permits in the statute, then they're not exempt.
If you want non-residents to be subject to the suitability requirement that residents are subject to, put it
in the statute. It is because here's what happens. In our case, the appellate court said, well, if you know all the applicants, you'll eventually know all of the people that have permits. So we're just going to... What they did was they corrected a flaw in the legislation, in the law. They corrected a flaw.
Well, what they
when
saw
in
as
fact,
a flaw.
let me finish, please. Okay. When in fact, had the appellate court said, no exemption for applicants, Mr. Peruta, you get all the applicants. Someone would have gone to the legislature with that appellate court decision and say, we need to amend the law. Look what the appellate court just said. We didn't write it right the first time, so we have to write it right now. Now the legislature sits back and says, we can leave the law as vague as it is. We don't have to worry about it because the appellate court's already ruled on it. We have a court case that legislated that did our job.
No, exactly right. When somebody else comes along and reads the statute and comes up with the same idea you did, and then they research it and they find our case, your case, and they say, oh, well, this didn't work. So basically what had to be done was they had to look at the statute and they had to look at the law. So you are exactly right. When the statute isn't clear and that court case takes it upon itself to interpret or to add to that statute, it is legislating from the bench, and Neil Gorsuch is against that. And thank God that Donald Trump was elected in 2016 to put Neil Gorsuch on the bench, and hopefully more people like him.
Well, I think that is a case that can be used in a wide range of scenarios. In other words, in such and such a case, bank versus such and such, or such and such versus the bank, had the legislature wanted to have the actual loan holder subject, they would have said that. No, they said that in order to be a debt collector, you have to be collecting for a third party. I have said this repeatedly, and the resources have never been there. Cases that are screwed up, for example, seize the weapons and then get the warrant. Went all the way up to the appellate court. The Supreme Court didn't take it, so it became the law of Connecticut under Connecticut jurisprudence. I think that issue will eventually find its way into the federal court, and the federal court may go like this. Are you crazy? You can't rewrite the law. the Fourth Amendment is the Fourth Amendment. So some of these hot political Second Amendment and First Amendment topics that you live with at the state level need to immediately go over into the federal court and have federal scrutiny, especially now that you have Gorsuch and you may have a couple of Gorsuch,
get his name right.
May
He
have
deserves to have his name right.
have another bite of the apple.
How good did I feel doing research for this case that I was working on, in the firearms case in Massachusetts, when I ran across this 2013 decision from the Massachusetts Supreme Court. This is the Massachusetts Supreme Court. It's Firearms Records Bureau versus Simpkin. And I will read you this sentence. Next, we suspect that the average Massachusetts resident may become alarmed on learning that someone other than a law enforcement officer is carrying concealed weapons in his or her presence. However, Simpkin is not responsible for alarm caused to others by his mere carrying of concealed weapons pursuant to a license permitting him to do exactly that.
That is Goldberg.
That is the exact argument I made to the Second Circuit back in 2008, 2009, and they thought it was ridiculous. That argument. It's the exact argument I made in Burgess. And how good does it feel to finally read cases that are coming around to that obvious point of view?
We're running out of time, so I need to be able to say this. I know how upset you were when your valid argument was rejected by every level of the court system. And I said to you, you are ahead of your time. The case law will catch up to your theories. You will sit down sometime in the future, and there will be a case that will justify everything you've said to this court. And Gardner v. Tennessee, in October of 1971, I drew back my firearm and did not shoot James Edward Carpenter in the back as a fleeing felon because he was unarmed and I didn't know exactly what he was wanted for. I got terminated based on that written reprimand on November 1st, 1971. I believe it was 1985 or thereabouts that the U.S. Supreme Court ruled in Gardner v. Tennessee that a police officer cannot shoot a person simply because he's a fleeing felon. So I had to wait almost 14 years to have the U.S. Supreme Court justify what I did or didn't do on the Berlin Turnpike in front of the Atlantic Motel on an October evening in 1971.
And with that, we will see you back. I will be back here tomorrow with Chris Janko.
I will not be here.
Have a great Wednesday.
What is that, ab initio?
We forgot about Flag Day. Well, you mentioned it.
I said it in the beginning.
He could have had that up the whole time if he wanted.